Thank you. Welcome, everyone, to House General and Housing. And it is, and still is, Thursday, April 24th. This afternoon, we're going to look at two of the bills that are before us. One is H-169, which is an act relating to prohibitions against discrimination in public accommodations and housing as they relate to nationality and to immigration status. Citizenship, and immigration status. And the other is we're going to return to S-127 and just tie up a few items which we heard testimony on or discussion and see if we can figure out where the committee is. So H-169, we've had testimony on it, and to refresh everyone's memory, the last thing we did was request legislative counsel to redraft the bill to some extent in light of the conversation that had happened here. And in fact, he went back and he let us know, particularly with respect to one issue, that he wanted to consult with his colleague, Maria Royal, who is here with us today. Welcome, Maria. It has prepared a draft, sort of another draft of the legislation. And I guess, first of all, is this online at this point?
Yeah.
Great. And you should all have hard copies as well. Are you able to put it up?
Sure.
We have Emily online, and if you can put it up, please do. And Cameron, take it away.
Good afternoon, Cameron Wood, Office of Legislative Counsel. I want to start by just identifying the sometimes sensitive nature of the conversation that we're talking about when we're talking about, immigration status of individuals here in the country, and given the circumstances of what are going on nationally, et cetera. Just acknowledging that at the outset. I will, do my best to, speak to the issue using appropriate terms, et cetera. And I just apologize if I slightly misspeak as we have this conversation. I know sometimes it can be difficult. So just starting that out at the outset. Some of the issues that we talked about last time we met and kind of walked through this. If you recall, we were discussing about the concerns with the bill as introduced. It prohibited the use of Social Security numbers in a rental application. And then throughout the remainder of the sections, it added citizenship and immigration status into the protections and public accommodation section of our law, and also in all of the sections for protections on housing and the prohibitions against discrimination in housing. There was discussion, as you all have walked through previously in previous testimony, about concerns in regards to lending and issuing credit. And there's a specific provision in the unfair housing section that speaks to that. You all remember this subdivision 6, and this is on the top of page 5 on the draft that you have in front of you. So just reorienting us back here. There's a prohibition to discriminate against any person in the making or purchasing of loans or providing other financial assistance in real estate related transactions. And if you all recall, we kind of discussed and walked through a few federal laws, federal regulations that allow banks and financial institutions to take into account someone's citizenship status when determining whether or not to issue loans. And then there was also discussion about their ability to sell those on the secondary market, et cetera. That's kind of where we left things off the last time I was here. So the kind of credit and banking and financial institutions that is not within my portfolio. And I mentioned to you all last time, that's in my colleague's portfolio, Maria Royal. And so I wanted to get her looped into the conversation and get her expertise on how best to help move this forward. So I did that, and she's here for us for a little bit. So I'm going to start with that piece of what we've discussed, and then we'll circle back around to the social security number and rental applications. Okay, so I want to start with the financing piece and credit and banking
You
institutions.
wish Maria to testify as well as yourself.
I can get us started and then, pass it off if appropriate, et cetera.
Maria, why don't you identify yourself for the record?
Maria Royal with Legislative Council.
Thank you.
Okay, so that's where I'm going to start here. So we did, both of us were doing a bunch of research and trying to figure out, how the federal law overlays. We talked a little bit about, preemption, et cetera. And so the last thing I'll mention before I kind of jump into the language is I simply drafted this, or I simply put this as kind of orphan language on a page. That's why when you go to the very top, it's not listed as an amendment to anything. Because as we've discussed in committee, you've talked about whether or not to include this in S-127, because part of this was in the housing bill that came to you, or you've also discussed about possibly doing this as H-169, which you have in committee on your wall. So, it's just orphan language here. We can insert it wherever you so choose. I did put in the heading possible amendment to 169. Okay, so I'm going to bring us back down to Section 4, which starts on page 3. This is the section related to unfair housing practices. And as you can see, in each of these different instances, we've added citizenship and immigration status. Again, we were kind of focusing on Section 6 here, related to loans and financial assistance for real estate related transactions, et cetera. So what we've added is going to be down here on the bottom of page 6 and the top of page 7. Subsection D says, if required by federal law, the verification of immigration status shall not constitute a violation of subsection A of this section with respect to the sale and rental of dwellings. That was in the bill as introduced. I reworded it slightly. If you all recall in the walkthrough, I wanted to reword that language to make it a little more clear. The reason that's there is because, as we've talked, there are certain federal dollars that flow to individuals where it's required that those dollars go to individuals who are lawfully here in the country. There's a little bit of depth to that discussion. Under the Biden administration, they've somewhat expanded that. So as long as my understanding, as long as one individual in the household is here legally as either a citizen or legally authorized, then they can receive those federal dollars to support the entire household, which may include individuals who are unlawfully here in the country. It's TBD of what the Trump administration is going to do and with respect to those programs. But, just to be clear, there are certain federal programs that can only go under the law, can only go to individuals who are here lawfully. So you have subsection D here to ensure that if it's required to verify someone's immigration status, that's not going to be a violation of the law. And then we get to subsection E, which my colleague Maria drafted. I'm just going to read it to you and then we'll kind of talk about it. It says, for purposes of subdivision A6, and remember that's the one related to real estate transactions, it shall not constitute unlawful discrimination for a creditor to consider a credit applicant's immigration status to the extent such status has bearing on the creditor's rights and remedies regarding loan repayment, and further provided such consideration is consistent with any applicable federal law or regulation. As we've talked previously, you have kind of more than two, but there were two primary federal statutes that we talked about last time I was here. I brought them up and shared them with you. You have 42 U.S.C. 1981, which requires that persons who are here are able to engage in contracts to the same extent as white citizens. We kind of talked about that. That provision also courts have determined applies to, quote, aliens. These are the words that the courts use, so I'm going to use them. Individuals, who are in an alien status and are not citizens. And then you have the Equal Credit Opportunity Act, which prohibits discrimination in the issuance of credit based on a list of criteria that you're all aware of, race, religion, et cetera. That includes national origin. Those are the regulations that you've walked through that allows credit institutions to look at immigration status as part of their determinations of whether to issue credit. So what we tried to do here is really just kind of, I don't want to speak for Maria necessarily, but kind of mimic and capture what's allowed at federal law and put it here into state law. So if a financial institution is using as part of their determination of whether to issue a loan to someone, they have under this language, it would not be a violation of state law to take into account their immigration status and whether to issue those loans. The last thing I'll mention, and then I'll just kind of pause and allow you guys to ask questions or discuss further. Again, there was discussion about concern on their ability to sell these loans in the secondary market, and what we've kind of come to the conclusion found is that for the two primaries that we've discussed, Fannie Mae and Freddie Mac here, they will take loans that are made to individuals who are authorized to be in the country. So as long as the loan is being issued to someone who's legally authorized to be here, we don't need to add any additional language to address those circumstances. So I'm just going to kind of pause there and ask if we have questions or where you would like to take the discussion on this point forward.
Okay, so as I understand it, what you're saying is we had two concerns that we wanted to address. One is the concern that just under federal law, it was permissible to look at for credit for lending institutions to look at immigration status.
Sorry.
And the second was the concern that they might not be able to sell a loan to someone who wasn't here legally. What I'm seeing here and assuming is that your intention is that both of those are covered by this. That by saying, well, obviously the first one is, but by saying that they have a right to consider it to the extent that it has bearing on the creditor's rights and remedies, that would include their ability to sell the loan.
Yes, sir. The concern was if you don't have any language like this, and it's in that subdivision A6, where you cannot discriminate against someone based on their immigration status, and I'm the financial institution, and I'm taking into account your immigration status and whether to issue a loan, and I deny one because your visa expires in 12 months, or you don't have a cosigner who's a citizen, or whatever the reason is, that's opening up the bank or the financial institution to a lawsuit that they've discriminated against someone. And then we talked about, well, but federal law allows them to take those considerations into account. And so that's where we've crafted this language to say, you bank can do that. You can look at, or you can take into that consideration their immigration status in determining whether to issue that loan. And because Fannie Mae and Freddie are saying, we'll take the loan or we'll buy it, or, there's no limitation on our ability to, using my words here, interact with the loan, as long as the individual is here lawfully, then this language would allow the banks to take those in consideration. There is a question about, what about somebody who is not here lawfully? What is the protection going to do, and what is this language going to do? And this is a open question when it comes to both federal and state laws that I've done research on, whether these laws protect individuals who are not here lawfully. There are certain federal laws that do apply to people who are here unlawfully. For example,
sorry, can I just interrupt real quick? I just think that it's so hard to be black and white as lawful or unlawful when there's a whole spectrum. And so it does make it, you can be en route to doing something. You can be, a slight overstay of a visa. There's all kinds of, so it just, if there's a way to just say, and my understanding was that the federal law, while it allows you the right to repayment. It does not allow you to look in isolation at immigration status.
The federal law specifically, and I can pull the language up again, it specifically authorizes financial institutions to take into account someone's immigration status in determining whether or not to issue them credit. It doesn't specify really beyond that.
I'm confused because I thought that was exactly the opposite of what
Maria,
I researched. Yes.
Yeah, I think that, there's the federal laws Cameron explained, and there's the regulations, Regulation B. And then more recently, in October 2023, the Consumer Financial Protection Bureau and the Department of Justice issued a joint statement. And I believe what they determined is under the federal law, one, you can't use immigration status as a proxy for discriminating against somebody based on national origin, race, whatever. You can take into consideration immigration status if it relates to the creditor's rights and remedies with respect to loan repayment.
Yep.
So you're right. You can't just look at their immigration status and say blanket, we don't lend to anyone with this status. But they can if it were, there have to be that nexus.
that's the bearing on the creditor's
Yes.
rights.
Ability to repay is.
Well, it's bearing on the creditor's rights and remedies is the statutory, is the phrase that's in the
In the joint
communication. in the joint
statement
statement.
and, yeah, so there may be, people may argue about the extent to which there isn't a bearing, but I think that's as close as you can get to the current interpretation of what's permitted. And others disagree with that. I'm a little bit new to the area, so, but that's my understanding, so.
Okay, if I misunderstood what you were saying, I just wanted to make sure that the committee,
Well, in terms of lawful and unlawful.
I think it's
that's-
clear in
if
the
you're-
writing.
Yeah,
I
we're not
think
using those
this
terms in
wording-
the writing.
yes, yeah,
If you're, I don't know whether you picked that term from somewhere else, but perhaps, I'm not sure what the right term would be. Yes, Maria, you had,
I'll let you go, Cameron.
I was just saying, as I mentioned in the beginning, I'm trying to be careful with my words here, but I'm also using them intentionally because whereas I understand there's a
Yeah.
host of
I
spectrum
just
of
wanted to make
people
sure
that
we
are,
say that, yeah.
immigrating to this country. I have seen courts specifically distinguish between and using the term lawful aliens here. And so that's where I'm trying to be clear that, as we discussed last time, you do have the memo from the Consumer Financial Protection Bureau. But as we've discussed, that's not law. That's an interpretation that very well could change tomorrow. And so when you're looking at the federal regulations, right, it doesn't say that, this says nothing about the actual qualification of the immigrant status. So that memo could be rescinded. The Trump administration could come out and say, it's not a violation of federal regulation for you to deny loans to individuals because they are not here lawfully. And then a court would have to determine, and Maria, jump in here if you feel differently, a court would then have to determine whether these federal laws protect those individuals.
Right. I
And
thought
I
with
can't
the
guarantee
joint
that outcome.
statement, I thought that the statement was essentially indicating that there were a slew of court cases that were establishing through the decisions that there were
That's-
abuses, that there were far more abuses on where this was not necessarily just to ascertain the creditor's rights and remedies. So I get that. I just want to make it clear that that's what it seems that the federal law is saying, not that you can discriminate based on immigration status. It's saying you can look at immigration status to determine whether you will be able to get your loan repaid.
Right.
As you would look at, anybody's income or I don't know, history of paying back your
That's two different things. Looking at someone's income and looking at their immigration status are two different things. Everybody's income is different. And it protects the lender by looking at their income. But somebody's status, like what's the difference between lawfully, unlawfully, and illegal?
I want to be careful here because this is not my area of expertise. The federal government has essentially sole discretion in setting laws as it relates to how individuals immigrate into this country, what their status is upon entering the country, what the status is upon their stay, and what the status is if an individual stays beyond whatever visa or circumstance got them here in the first place.
What if they're asylum seekers?
And so that's where I'm trying to be careful. That is a very detailed federal process about how individuals come to this country and seek asylum, and then what happens afterwards. And I'm not an expert in that area, so
Yeah.
I want to be careful and not overstepping or explaining something that I'm not an expert in or have the knowledge to share. Mr. Chair.
Mark?
Can I
Please,
just say,
yeah.
I just want to quickly I just wanted to like, just put that out there. We cannot litigate immigration law and we're not in this bill. And I just wanted to make sure that what to me sounded like, oh, there's a very clear bifurcation we can make, like, isn't the full picture. And that this language, if we look at it, is actually quite nuanced. And what the joint statement indicates is that what the case law seems to indicate is that people who are following this in a way that does allow discrimination solely based on immigration status is not actually legal. And they, to the point that they were sending out reminders, look at all this case law that proves that, you know, people who are abusing this are not being, you know, that is not being found favorable. Does that reflect at all,
I want to
Maria?
respond to that, but I was going to let Maria jump in first real quick.
I think it does. And two things I just wanted to say, and I think Cameron's right on point. So in terms of who is legally present here, documented, they can be work permits, student visas, asylum seekers, refugees. Exactly how, when you attain that status, that I understand the process, it's a great question. You might be in a process, as we've all seen, and not have the documentation. That's a federal issue as to when you actually acquire them. The only thing, and Cameron alluded to this, and I just wanted to make sure I was also clear on this, in terms of the secondary mortgage market. They will buy loans if you are an immigrant and you're a documented immigrant who's legally authorized to be here. So the question that I think Cameron was getting to, what if you're a bank and you want to lend to somebody who is an illegal alien or an undocumented immigrant? They won't be able to sell that to Fannie Mae and Freddie Mac. You know, whether banks want to do that, what the risks and financial exposure, I don't know that that's going to happen, and it may, and there's a huge tension. That's where you really get into preemption issues, because if the state is requiring even a state entity to provide lending, are you encouraging people to be present illegally? And does that contravene the federal government's authority over controlling who can lawfully be present? So.
Right, no, I think our goal, yeah, I think
I went too far, but.
No, it's okay. I think the goal, I think that the language that Cameron showed us jives with the language that Cameron wrote for us. And I just wanted to make sure that all of that was clear, to make sure that, because I feel like I was not hearing as clearly what like, the purpose of this language is certainly not, it's the opposite, right? We're trying to reflect what the federal law is saying, and so
And
hopefully,
I have a question about another provision that you just read. I mean, D,
yes.
well, one is a technical one.
thank you.
Run off to another committee, I'm available.
Actually,
Other
wait,
questions? Yeah,
Thank you.
I guess I'll ask, can I ask you a quick question?
of course, yeah.
It says a creditor. Don't we mean lending institution? A creditor could be a department store that sells you a dining room table and takes interest in the dining room table, or a credit card company. Don't we mean lending institution?
Well, it's a good question. So I was thinking that broadly under the Equal Credit Protection Federal Act, which is all creditors.
It's all creditors.
But in this statute, it refers to housing, residential, I think the intent is mortgages, so. I think that's a good question.
Okay, either way, it sounds
I
like,
think it's a good
I get it.
question.
Okay, all right. With the, if we wanted it to be narrower, I think I'm okay. Could we say lending institution?
Yeah.
Okay,
Yeah.
great, thank you. D, if required by federal law, verification shall not constitute a violation under subsection, did you mean A?
Yes, sir.
A is the one that says that they can't charge for an application fee.
No, this is subsection A of this section 4, and section 4 is related to unfair housing practices.
Yeah, okay. Two thoughts. Subsection 4A, okay. I guess,
Do we want to specify 4A6?
no, well,
You don't need to.
Oh,
I don't
okay,
think we
great.
need to. Just one thought I have. You know, as you know, I mean, I'm fine with this. I'm just wondering if we don't need more. And perhaps it's in here and you just haven't gotten to it. But we need some sort of broad protection where we say that the provisions of subsection A don't apply where they would contravene federal law. Not just a verification of immigration status, but if federal law places landlords are very concerned that they would be caught between federal law as it evolves. I mean, what happens if there's a federal law that says you the same, that uses the same language as the creditor's language, says you can only rent to people who are here lawfully.
That's what D said.
Yeah,
So this.
we need some sort of broad protection so that landlords are not caught between federal law and state law, and it goes beyond the verification of immigration status, in my view.
My immediate reaction to that is one of legal skepticism of whether federal law whether we're going to get there. And I'm not trying to dissuade you from doing what the committee would like to do. It would be a federal law that would prohibit private individuals from entering into their own contracts. And I'm not sure what authority. I'm trying to contemplate what authority that the federal government would have to do so.
Well, there's all kinds of possibilities I can imagine. I hope none of them occurs. One of them would be a mandate that credit companies only not provide credit services to people who are not in the country law.
Well, I think
that
you're covered there under E. Because it says,
Just the rent.
provided further that such consideration is consistent with any applicable federal law or
where
regulations.
is this?
This is on line 20 and 21. Now, this is just to creditors, right?
That's just to creditors. We're
private.
talking about landlords.
Right, but I'm
In other words, what happens if a landlord can't? We did all this work to show, and we believe from the testimony, that a landlord can get, they can get a credit report. They can do background checks without a social security number.
Right.
What happens if they can't? Because federal law has made it impossible.
But that's where I'm getting to, right? So the federal government has, I think, pretty clear authority to regulate financial institutions under Commerce Clause, right? I'm trying to understand under what federal authority the federal government is going to come in and tell private citizens that they can't enter into private transactions with individuals based on.
We regulate, there's all kinds of federal regulation over the conduct of credit. It happens all the time.
I'm not disagreeing with
Yeah.
you. I'm just.
I'm coming across that I'm advocating this. I'm not. I think everybody knows that.
Yeah.
I'm just feeling like as a practical matter, that's why we put it in the concepts. We need to see something that protects landlords broadly against getting caught between evolving federal law and state law, I think. And I don't think it would hurt the intent of this bill to do that. I hope you're right and that there are legal challenges possible to any such efforts, but I wouldn't want landlords to feel like they were exposed. Anyway, that's just my thought.
Just,
Yes, yeah.
just real quick, I haven't added anything here. I'd want to think about it, but
Yeah.
conceptually, we could add something. Yes.
The testimony that we heard about getting credit reports without using a social security number. They said that the information may not be as good as if you had that social security number. So that's a tool that landlords want to use. They don't all have to use it, but I feel like if you want to know as much as you can about a person that you're going to enter an agreement with, and that's a tool that you've been using for a long time. And yes, we had testimony, you could get it another way, but they also said that it's not going to be as accurate.
Other comments on this?
Wouldn't your scenario be totally negated by the, if required by federal law?
Well, but this section, I agree, it would be. But that's not what,
Questions?
this is only about verification of immigrant status. If it was required by federal law, subsection A shall not apply, that would take care of it.
I want to think on this one a little more. I was not anticipating that.
Yeah. No, I understand.
I think D may cover it. I want to think about it.
In fact, I was hoping, I don't think that landlords should be required to verify immigration status in any way. The problem is some are because they got federal financing. So they are, and that's what D is designed to deal with. There's federal law that says they have to verify immigration status. But so I don't know if it says what they have to do with it, but that aside, I'm suggesting a broader problem.
And I will say on that topic, there is one case I have found in the Fourth Circuit, which is not our circuit, that indicates that discrimination against individuals who are unlawfully here, these are words that the court uses, could be a violation of the Federal Fair Housing Act.
I'm sorry, say again.
Could be a violation of the Federal
What
Fair
would
Housing
be?
Act. Policies that specifically exclude individuals who are unlawfully here, housing policies.
Right.
Landlord who is saying, you have to prove citizenship to me in order to rent or lease here. And the court, in that instance, it was an appeals court, so it's not a Supreme Court decision, allowed that case to move forward on a disparate impact argument. So implying that if you're creating some sort of policy specifically excluding individuals who are here unlawfully, that could be a violation of Federal Fair Housing Act, which
I
requires
mean, it would be a violation of federal fair housing law.
not,
For an applicant, for a landlord to have a policy verifying immigration status.
it could be.
Yeah,
The court didn't say it is. It's-
actually, I'd be happy if this said verification of immigration status shall not be required of the landlord unless required by federal law.
Yeah, that works.
You can add that, absolutely. There are similar language in some of the other states that we've reviewed that is.
I mean, because I don't think landlords should. I think a statement saying they're not required to, at the very least, that they're not required to verify immigration status unless federal law.
Because that makes them
Yeah.
much more likely to become, you know, either repositories for information that somebody would then, you know, demand of them. You know, or liable for doing something if something changes, right? Does that make sense? But Debbie had asked about, well, we'll get to that.
Yeah, I'm not
We're
ignoring
we're
what Debbie
focusing
said. I
on-
just wanted to focus on this issue. So I don't know how other people feel. I'm just suggesting that Cameron work on a little broader protection of
Protection.
landlords and that perhaps flipping this D so that there's a statement that there's no requirement unless required by federal law. I just hadn't gotten yet to the issue.
Because we're,
Yeah. Now,
The
go ahead,
exceptions.
please. You were gonna address what Debbie said or
no,
whatever.
I just wanted to make sure we did.
Yes,
we
we're gonna
didn't
circle back
not-
around to
Yeah,
that here in a second when we get to the top. So I'm just bringing us back to the subsection E here.
I'm okay with that personally. I mean, it's true, creditor is a little broader than I'd hoped, but on the other hand, this whole section just deals with, this whole law just deals with landlords, so.
So again, the things that I can't guarantee you are you have the federal law. I haven't found a case that deals with someone who is clearly here, who is here unlawfully, that is making an argument that denying that individual credit is a violation of either federal or state law. What I read that memo from the Consumer Financial Protection Bureau is to say, you financial institutions need to understand that if you're going to not accept any applications from any immigrants, that is potentially, and it does not use assertive language or guaranteed language. It may be a violation of federal law and it may fall under the violations of national origin. So even the memo is not explicitly clear. The cases that I've seen, as I kind of discussed with you last time, were circumstances where banks were doing just that. We're not allowing individuals to file an application for credit if you don't have a social security number. Somebody brought suit, you're discriminating against us based on these factors. These were in California or where I found them. There was one in Nevada. And the courts were saying that is a potential violation. Again, these were getting kind of the legalese of this. The courts were determining whether or not motions to dismiss were appropriate. So it's not the court deeming them to be violations, but it is saying that the cases should be able to move forward and that it could be a violation. You as a credit institution are denying people the ability to apply if you don't have a social security number, for example. So I think what your language here does is if you're going to put citizens.
That's E.
Yes, sir. Still talking about E. Yeah.
I think everybody's okay with each.
And I just want to be clear, what I can't guarantee you is that what could happen is if someone is here unlawfully, the question is, will the protections that you're putting into place guarantee those individuals access to credit? And what I'm saying is,
Yeah.
I can't guarantee that it will. In that we're putting in here that a bank can take that into account. And if they're denying people because we're taking into account your immigration status and given the current circumstances and what's going on with the federal administration, it's too risky for us. Somebody could then sue the bank. And I don't know, because the court has not specifically stated that these protections would apply to those individuals. And that would be something that a court would decide at that point in time. Okay.
Can I ask a question? Did the concept? I know that, Director Hartman from the Human Rights Commission had tried to offer some language for the banks that was very specific about the reselling of loans and that issue. Can
He
you tell me-
reviewed that with
Yeah,
Maria,
can you speak
and
to
this
me
is what came out.
Okay, can you tell us how that conversation went? That's
Sure.
why I-
Oh,
I'm
Yeah,
sorry.
for others, as we talked about kind of at the beginning, there were a few different concerns that were being raised in regards to financial institutions and the issuance of credit, et cetera. One was, federal law allows us to take these things into consideration, and if you state, don't put something similar in, and we're doing what we're allowed to by federal law, you're potentially opening them up to lawsuits, and then there's a question of preemption, et cetera, et cetera. Adding this language, I think, resolves that issue. And then we talked about whether or not these entities would be able to sell these loans on the secondary market. And there was concern that they wouldn't be able to sell any loan that's not to a citizen on the secondary market. And so some language came over to us from the executive director of the Human Rights Commission that said something to the effect of requiring a social security number, so it won't substantially impact the bank's ability to sell on the secondary market, wouldn't be a violation of this section. My concern with that language that I shared was, and I've said this to this committee, I feel that that sort of exemption swallows the entire protection. What I mean by that is, if you put language in here that says, if you want to or need to be able to sell the loan on the secondary market, therefore it's not a prohibition of the discrimination to deny people because of that, then that's what they're all going to do. They're all just going to say, I need to guarantee my right to sell this on the secondary market, therefore I'm not loaning to anyone who I can't sell on the secondary market. And that's my concern with that.
Got it.
And so the executive director did point out, yes, they acknowledged the concern, but they mentioned that there's still other discrimination that could happen that it would prohibit, this would prohibit. And so with the additional research that we did, where we found that financial institutions can sell any of these loans on the secondary market as long as they are to a citizen or someone who is lawfully here, the entire concern kind of goes away, because we have this language that allows them to take into account immigration status.
Built into that language.
Yes, sir. So. Okay. I'm happy to come back down to this piece, but I'm going to bring us all the way back up to the top to talk about the other pieces that were in 169, which is on page 1. And if you all recall, initially this was drafted to say that a landlord is prohibited from requesting a social security number, and a landlord shall accept any form of government issued identification. There were some concerns about how that was drafted, so we wanted to phrase it in a better way. I was doing my best to come up with something and was, I would say halfway there, and then spoke to the chair and he helped me hopefully get to a place that you all would be supportive of, which you have here in front of you. So it's in order to conduct a background or credit check, a landlord shall accept any of the following: a social security number, an individual taxpayer identification number, or an original or a copy of any form of government issued identification. And there was also the discussion about wanting to ensure that there was some sort of on the ground practical, how do we ensure that the applicant is aware of this information? And so what I added was in the sub 2, a residential rental application shall inform an applicant that the applicant may provide any of the above forms of identification in order to conduct a background or credit check. So how this is going to work is, a landlord can ask for a social security number, and then the individual doesn't have one, they can give their individual taxpayer identification number if they have one. That's how individuals who are, don't have a social or maybe here on a temporary status, who's wanting to ensure that they're able to comply and pay their federal taxes, can get an individual taxpayer identification number. We talked last time, it's still a 9-digit number. It looks like a social. If they don't have one of those, then they can provide a copy of a government issued identification that the landlord could then use to do the credit or background check. So this circles us all the way back around to the concern that was raised. And, I don't know that I can offer you anything other than what you've already heard, which is, the best information we're going to get as a landlord to do a background check is the social security number. We can do a background check using other information. It may not be as robust as what we would get with the social security number. And that is then the policy decision that you all get to make. Are we wanting to allow for something other than the social? Or do you want to keep status quo?
To be clear, what this language is doing, remember the bill was originally drafted, just prohibited asking for a social security number. And I guess my concern was, in 99% of the transactions, landlords are going to be dealing with somebody who's got a social security number, asking for it and get it. And we don't want, there are some problems with this approach in terms of, but the idea here was that a landlord, the applicant has a choice as to what they give. The landlord, if they don't have a social security number, they can give them something else. What the testimony was, as I recall it from the Champlain Housing Trust and from the American Apartment Owners Association with its 153,000 members, was that there's no problem getting a credit check with date of birth, ID, and former addresses, and that there's no problem getting a background check. There are some specific problems that emerged from the testimony. One is there may be a problem if there are many people who have the same name. There may be, I'm not sure how real a problem that is in Vermont, but
But you
there-
said that it's usually resolved by
but-
checking the address.
it's checking the address.
Yeah.
And I seem to remember Angela, I've forgotten her name, Angelica.
Zakowski.
No,
No,
that's the Landlords Association. No, it was the one from the American.
Oh. I think her name was Alexandra.
Alexandra. Anyway, she seemed to say that in terms of getting some criminal records, it's a little harder to get if you don't have a social security number, I remember. But I may be wrong. You'd have to check. In other words, she said that they do it all the time. That is, get all the background checks they need without socials. But there are some situations when it's not quite as good. I think the bigger problem, I'm just saying from my perspective, one, we are not dealing with this in this bill, but I would like to pursue, is that a lot of people simply don't have credit. They don't have a credit card, so they don't have credit. And they don't have a credit history. And unfortunately, paying rent off every month. If you could have the most perfect tenant who pays every month and it just doesn't show up on their credit report. And I am under the impression, but I don't know for sure, that there are states that have actually addressed that by requiring credit companies to report payment of rent as a successful payment of rent in credit reports, thus helping people who are, they just don't have the money to have a credit card, or it helps them build credit. But we have not dealt with that, and I would be open to dealing with it in the future, but
I
it's
think
not this.
Mike Pichek had a bill about, or there was a bill about that, Mike Pichek was brought in, I think, last year. Say, do you remember that? No, that had to do with your diligent rent payment showing up as a positive on your credit score. Wasn't that what? I can't remember
I
whether
remember
it
the
passed or not,
conversation.
but
This year,
was it this year?
well, or one similar.
Are there any other changes that you want to bring to our attention?
No, sir, that's it. You have the change at the front regarding the credit and background check, and you have the change at the end regarding the ability of financial institutions or creditors to take an addition.
That's much. On page one, B, C reads an original or a copy of any form of government issued identification. And I'm wondering if that might ought to be current form of government identification. I'm thinking of,
You
well,
mean current form, or do you mean form of current?
I'll ask him.
Do you want the form to be, what you want is, like, let's say somebody gives you a passport. Are you saying it has to be a passport that's not outdated?
Yes, a photocopy of my passport from Liechtenstein when I was a college student. It didn't look this good. You can't tell it's me. I mean, that fits. Not from Liechtenstein. Right? Doesn't have a visa stamped in it. I mean, it's outdated. It's a government issued identification. It's got a picture in it. But does that, and then I put a landlord hat on, I think. I'm dubious. So which way would I phrase that?
It would, I think something like, but I think would be for Cameron, it would be something like copy of any form of government, current
Current government issued.
ID,
Or valid?
or
Valid,
currently valid, current and valid.
And then I just had a quick question on top of that, on that same section, where you finish, but when you finish, train of thought.
Oh, no, it'll keep going all night.
No, I was just wondering, and this is really trivial, and I don't know. I'm gonna just say what I was gonna. Is it possible to swap A and C on that?
Yes.
There's the ordering of them. I would like to see the order of the listing. I know there is no particular order because it's saying any of the following. But for me, just if that is at the top, it seems like that's a higher, there's a hierarchy. It's implied, but even though it doesn't really exist. I know it seems trivial, but I would, that would make me feel slightly better, even though it's not really a big difference.
Because it's more of the umbrella term.
Yes, I see that I see where you're going.
Yeah, you know what I mean? So,
But
yeah,
more of a
It's
communication
more of the
subject.
umbrella term for what we're looking for, right?
right.
Or is that what you mean? No, I'm sorry.
I'm validating your
It's just
thoughts,
showing that it's
and
not
if
necessarily-
you all would like that,
It's a policy
It's an
decision, not
implication.
drafting.
Oh, okay.
Writing
So it's up to us.
Oh. Do folks feel okay about that?
Yeah, I think that makes,
Mhm.
I think it makes sense because we're talking, that is what we're.
I agree.
Yeah, I agree.
Your voice sounds a little better this afternoon.
It's getting a little better, yep.
She's propped up by prop 3.
I'm
Um,
listening.
yay.
Can
I ask a question? So this in conjunction with the rest of the bill that lays out the unfair housing practices. Do we need to spell out more clearly that that even though people can offer all of these things, that you can't, is it gonna stop landlords from requiring a social if they claim that, it's the only way they can do a background check?
I don't think. I think that would violate B1 expressly.
Yeah, I would agree with the chair. Two things. I would say, the way I read B1, to discuss, with the chair, first off, even without B here, let's just pretend B isn't there. And the remainder of the bill goes into effect. So you've added citizenship and immigration status into the fair housing sections. And a landlord says, don't bother applying unless you have a social security number. I would argue that would then be a violation of the fair housing sections, and the landlord would be subjecting itself to suit. One could argue that's a violation now because you have things like national origin is already a protected class there. And as I mentioned earlier, there are arguments that have been made in other jurisdictions that the Fair Housing Act would specifically prohibit that. Adding citizenship and immigration status, I think, will just reinforce your policy and expectation there. So I think B1 would then make it even more clear or more explicit that you, landlord, shall accept these other forms of identification. And so if a landlord is saying, I don't care, I want the best background check possible, therefore I'm only taking social. Here's my ID, too bad, give me your social security number, or you put on the application, if you don't provide a social, need not apply, or something to that effect. I think it would be a pretty clear violation of that section. And I think it would open the landlord up to a pretty good argument that they're violating the fair housing provision. Because, as we talked about, with the spectrum of people that are here, not all individuals have a social. And so I think by nature of doing that, you would be discriminating against people.
Right.
I think that would be a fairly easy argument to make to a court.
Okay.
Do you feel, Cameron, you have explicit enough reaction from the committee that you can produce another draft?
Yeah, we talked about rearranging the A and the C. We've talked about, I will circle back with Maria in regards to your concern, Mr. Chair, about the creditor and the subsection E. And we'll take a look at it. And then we've also discussed about the concerns for landlords, and do we need to have any additional protections here in the event of
Other federal law beyond the one that's in D. Debbie?
How are we handling the Service Member Civil Relief Act?
That
It was, we got testimony.
testimony
Yeah, we
that,
got testimony from Legal Aid, Mary Ellen Griffin, and she brought one of our cases forward where we have them in our lease. They signed that they're not a member of the military. She brought that case, but I asked her, I said, why didn't you bring my latest case where the judge did not take that? And then we have to spend more time. I mean, I had a social, so I used it, but it's like the things were delayed in that whole process, in that whole court process.
I think regardless of what we do, this is what I think. regardless of what we do here, that form has got to have some sort of indication. You know, you're making an assertion that they're not a service person. That assertion has to be based on some evidence that's current. And no matter what we do, that would have to be the case. And I think that the testimony we had was that if you go through the website where that's determined, not only you don't need a social security number, and in fact, they kind of discourage it.
Well, it says it right there. It
Well, you-
says right on the
yeah, you
website,
can
you
use
cannot request a social security number for the purpose of looking up this status on the website. And she showed us
Right, she
screenshots.
showed it's using name with birthday.
Well, she showed us the screenshot where it
Yeah.
literally says you can't ask for a social in order to check their status, but.
So I don't
Yeah,
think
that's
this
what
is,
the
I
court-
think.
So I think name
you're
and
pro-
address.
The you can do it with name and address, but the problem is, which you're alluding to, is it has to be current. In other words, you can't, I think one of the problems with getting some assertion that where they sign that they're not a service person, and then a year later, they don't pay rent and you go for a default judgment, I think you have to have searched just before you filed or something like that.
Some lawyers request that, yes.
I did hear, Debbie, though I am not an expert in this at all, that it's possible to ask people to waive the entire thing, right? I just don't know if that's true.
To waive the right to
To
that,
just waive the right
to the service member
to the
protection.
service member protection.
Yeah, but that's not our concern, right? Is it? I
No,
mean, I
I'm
think our
just saying,
concern is if a court asks you for it, what do you do? And what we heard was that, you know, in most, like pretty much most cases, she described, like, not only are you not allowed to ask for it, but you are allowed to provide other forms of proof
Right.
that certainly can't, you know, don't have to be only through the website, through that report that you could get from the website.
Yeah, the form that the court has there, they do send you to that website.
Right, well, and that you can do the website without a social security. Emily,
Oh, yeah. Also, I wanted to ask, I forget, what's the, Cameron, what's the, enforcement again? Is it with Big and those folks? If there's a complaint? Is it with the Human Rights Commission if, someone feels that they're being, like, if, for the enforcement aspect, I can't recall.
Under the unfair housing practices?
Yeah, Why
Yes,
can't- okay, so it's Human Rights Commission.
yes.
Okay, thank you.
So let me just get this straight. So we are. Sorry, Emily, did you have a follow-up about that?
I didn't. I was just having a memory lapse, but I just wanted to think about if what that would start to look like if folks were not complying with this, or if there wasn't enough outreach to people, you know, and just thinking about that further. You know, I know that they do a very good job doing outreach about different things, but I just couldn't remember who was in charge of kind of monitoring and handling those if there was issues with this, since it's a newer piece. That's all. But no further thing. Thank you.
Very quickly, I haven't done any research on court cases that may be interpreting this, et cetera, but you can waive your rights under the Service Member Civil Relief Act, yes. You have to do it while you are an active military member. So if you were to rent a piece of property, then join the military, then subsequently, be deployed.
Which
A waiver given at the time you entered the rental property would not be effective, but yes, I'm renting to you. Are you an active military member? Yes, okay. I want you to sign this waiver. Again, that's a very
I see.
blanket statement saying you can waive them. What are the nuances as is associated with that? Would need to do much more research.
Right. Well, I think Cameron, am I okay in saying, Cameron, we're gonna wait, have Cameron redraft this a little bit and we will schedule it promptly, hopefully, and discuss it one more time and see where we're at. Okay? Okay.
Either way, it's not vote on the bill because we're not.
Right, we're not sure where it goes. Right, yeah, okay.
Would you like to switch
127.
back to 127?
Oh, all right, Emily's giving us thumbs up. All right. Well, now we are turning to 127. Want to put it back up?
I've got a question. About 127. Specifically about the two studies. Over the lunch break, I saw a person who has interest in both of the studies. And we talked about, I asked this person about including people with lived experience would be the best, just as we had talked about before. Would be, what's the best way to say that? And the person said, what you should really be worried about is the fact that the federal government is slashing a lot of these agencies almost completely. So my question is, what happens if they don't really actually exist after this bill is passed, but before it's convened?
Let's run through the membership, because I'm just wanting to. I don't know that we have any specifically federal agencies or entities on the membership.
Vermont Center for Independent Living. The person said, which I said that we had talked about putting that as a place to find somebody with lived experience at the Vermont Developmental Disabilities Council. They will most certainly be gone.
I don't know that my immediate reaction would be this, assuming this passed and
Let's assume that that happens and that this passes. And so now we are Tuesday when it's already, it gets dry from the governor's signature and whatnot. Just for funsies, if something happens so that those agencies are, not agencies, but organizations are gone, what happens?
They're just not appointed.
So first I would say, I'm thinking about it this way. If there's a concern that the funding is no longer there.
No, I'm not concerned. I'm just asking about the makeup. Can you still convene the group without the full membership?
Yes, as long as there's a quorum of the number of individuals. Yes.
Okay.
So I would also, if I were talking to that individual, I would say, I don't know simply if there are cuts at the federal level that is going to somehow make the Vermont entity disappear. My assumption is these entities are most likely registered nonprofits in the state.
Well, Vermont Center for Independent Living, for example, is mandated by the federal government, funded by the federal government. And while the federal government may not, while the president may not do away with it specifically, the president may do away with everything to do with people with disabilities. And, and so regardless of whether Congress decommissions that effort, the president can do what he seems to have done already, which is to call for a drastic reduction in funding, which in a small state like Vermont,
And that's where I was, to jump in, and that's where I was kind of thinking was, you have the per diem built in, so as long as these studies are provided a budget, then the individual, if the entity still exists, then the individual should still be able to participate, and if the federal budget cuts are such that they can't cover that time, or that individual becomes an unpaid representative of said entity, then they could be at least provided the per diem
Okay.
of the, if these are provided money in the budget. If it is, we're an entity required by federal law and we're going to give you $0 and we've frozen you out of any dollars that are in theory, have been appropriated to you. And then the entity has no other funding mechanism and has to lay everyone off. Question as to whether somebody could act on their behalf. I assume, I don't know. I honestly don't know the answer to that.
I just meant in terms of the bill, in terms of the language of the bill, does anything need to be changed if,
I don't think so.
okay,
The committee will still be able to, this committee, the Universal Design Committee or the other committee, would still be able to operate as long as they have a majority of their membership.
okay,
And then, of course, they could, these individuals could still participate in a voluntary capacity, even if they're not able to participate in an official capacity.
okay.
A question, before we go into, we don't have a lot to do on 127. Do people want to just power through? Or would you like to take a break and come back at 3? People need a break?
I can take a break.
Okay, let's take a break until 3 back, just a bio break, as they say.